First thing that we want to talk about is what is mediation? Again, some of you may have some familiarity with mediation, but I don't like to assume that. So let me first try to explain what mediation is not. Okay. Mediation is not litigation. Litigation, quite simply, litigation is a lawsuit. That's taking advantage of the legal system where a party that's aggrieved files a lawsuit against the party they believe has aggrieved, whether it's a contract dispute, whether it's a medical malpractice, whether it's a property dispute. And those two sides then submit themselves to the court system and all the rules that go with the court system and all the costs that go with the court system. And it culminates either in a settlement, if the case is settled before trial, or a trial, which can be in front of a judge, which is called a bench trial, or in front of a jury, which obviously is a jury trial. And then the fact finder, the judge or the jury, they reach a result. And that's printed up into a verdict, which is converted into a judgment. And that's the end of it, with the exception of appeals and so forth. But there's a winner and there's a loser. That's litigation. Some people think that mediation is like arbitration. Arbitration is slightly different than litigation, but it's mostly the same. In arbitration, you're still having a trial of sorts. It's just not in front of a judge or a jury, but you're having a trial in front of a person that the party's designated, or sometimes if you're a member of the American Arbitration Association, the AAA, they will designate a person, typically a lawyer or an expert in the field. If it's a construction claim, it might be an engineer. And this arbitrator will sit and listen to this trial. Both sides will put on their side of the case, and then the arbitrator will make a decision in much the same way that a judge or jury does. And again, that's converted into a judgment. It's a little less lengthy than litigation. It's a little less expensive than litigation because some of the rules are streamlined, but by and large, it involves lawyers and experts and depositions and discovery and all the things that are features in litigation or lawsuits. So that's litigation, that's arbitration. Now, what is mediation? Mediation is, simplest terms, mediation is a settlement conference. Pretty simple, right? Settlement conference. Mediation got its start about 40 years ago in the labor and employment field. Some of you may remember back when Major League Baseball would have a dispute with the Major League Baseball Players Association, and they were going to threaten to go on strike because they couldn't come up with an acceptable labor agreement. And before they went on strike, they would meet in Washington, and it would take days, and the meetings would be presided over by a mediator. And the mediator was attempting to get the two sides to get together, to compromise, to reach an acceptable solution to avoid a strike. And it happens also in other labor fields with big companies, factories, between labor and management. That's where mediation got its start. Florida was one of the leaders in the country about 25 years ago in developing mediation, not just for labor disputes, but for garden variety lawsuits and claims. They devised this system. They required lawyers to go through a training period to become certified as a mediator. And as a mediator, once you got certified, you could mediate disputes, any kind of disputes. They divided it into civil disputes, which is basically folks fighting over money, versus family disputes. This would be like divorce, child custody, guardianship, things like that. So a mediation is a conference that's attended by both sides to a dispute. It is presided over by a mediator, such as myself. someone who has training in trying to work with people, work with companies, work with two sides who, for whatever reason, are involved in a dispute, in the hopes that by meeting with both sides, first together and then separately, and going back and forth, kind of like a shuttle diplomat, going back and forth, carrying proposals and counter proposals, discussing the claims and the defenses to the claim, playing a little bit of a devil's advocate role during this mediation, a settlement can be reached. A resolution can be reached, which, if it does, again, gets printed in a binding document that has the force of law behind it so that people can't back out of their agreement. It is much less expensive than either litigation or arbitration. It is much less time consuming. Most mediations are either half of a day, or, if depending upon the circumstances, could be an entire day, but the vast majority are done in half a day, which means that they are very time efficient. They are very cost efficient. In Florida, which, as I said, leads the nation in mediations, forgive me, my phone is going off and it's tied to my computer, so I'm trying to shut it off. Forgive me for that. So, mediation is a settlement conference. It is voluntary, meaning that if you don't reach a resolution, if you can't negotiate to a resolution, everyone walks away. Everyone returns to their original position. There is no prejudice to either side. Mediations by law are confidential, which means that nothing that is said or done in mediation can be used in any way, shape, or form in any lawsuit, in any arbitration, in any litigation. So, and the reason for that is very simple. It is to encourage candor. It is to encourage frankness without the threat that if you concede something to your opponent, it's not going to, they can't use it to hit you over the head with it if you ultimately cannot resolve your case. Mediations are in Florida. Once a case is in litigation, most of the jurisdictions in Florida, most of the circuits in Florida require that a case go to mediation before it can go to trial. And again, that serves kind of a docket clearing mechanism. The Florida courts are extremely crowded. It takes several years to get a case from start to finish all the way to trial because of a lack of judicial resources. And so, as a way of kind of thinning out the dockets, the courts in Florida have entered uniform orders requiring that cases will be submitted to mediation before a trial date is set. But of course, in many instances, the case has already been going on for a year and a half, sometimes 2 years before that mediation takes place. In business mediation, we have the freedom to convene a mediation even before a lawsuit is filed, what's known as a pre-suit mediation. All the same rules apply, but without the delay, the cost, the aggravation of having to submit yourself to this legal process with depositions and having to respond to discovery requests from the other side and lawyers and motions and all the things that go into making up a lawsuit, which are a drag on the company's time, money, efficiency, because your employees would have to submit to this discovery process, which is a very inefficient way to run your business. So the idea is to convene a mediation before all of that happens and save the time, save the money, save the inefficiency, in hopes that with the help of a mediator, you can resolve this dispute, untie the knot, as it were, untie the knot before the knot gets pulled too tightly by both sides to where it's impossible, or certainly very difficult to untie the knot later, and certainly more expensive to untie the knot later. That is, in a nutshell, what mediation for business is. What I've been talking about for the last several minutes. How does mediation work in business? Obviously, there are times in your work week, your work month, your work quarter, where things are not going smoothly on a particular subject. As I said at the beginning, it could be an invoice that hasn't been paid. It could be a product that you have shipped that the buyer of the product claims does not conform to what they ordered, and so they don't want to pay for it. It can be any number of issues that put you at odds with someone that you're dealing with in business. And what happens all too frequently is, if it can't be resolved quickly with a phone call or a trip or an explanation, if it can't be resolved quickly, what ends up happening is both sides tend to retreat. They retreat away from each other. And now you're getting into an adversarial position with a customer, a vendor, a supplier, a competitor, a partner. You're getting adversarial with them. And so now your options are getting limited. Maybe you thought, well, I did my best. And they don't see things our way. So you throw your hands up and everyone lawyers up. And now everyone really retreats, because now, once the lawyers are in control, and I know this because I have represented companies and individuals for the better part of my career. Once the lawyers are in control, lawyers do what you pay them to do. They do their best to win. They do their best to present your case in a manner that either 6 jurors or a judge are going to agree with, and that requires them doing a significant amount of work. They don't just walk into court not prepared, and work means time, and time means money. So that's what typically happens in business when businesses get sideways. If they can't resolve it early on, they retreat, they lawyer up, and then we're off and running, submitting to the court system, which is not particularly efficient to help get you what you need. I say to people all the time in mediation, it's like the Rolling Stones song. It's not about what you want, it's about what you need. What do you need to move forward? And with a mediator's help, a mediator can identify, with the help of both sides, because the mediator is independent, is neutral. We're Switzerland, but we are trained to be able to identify what the issues are and to be able to suggest to both sides different scenarios that it doesn't get you everything you want, but it gets you what you need to be able to move forward. And that goes for both sides, in hopes that by serving as this shuttle back and forth in the present, we're now, we live in a Zoom world now. Hopefully, we will return to a world of in-person mediations, because they work very well in person. In fact, I can tell you that mediation in Florida has about an 80% success rate. That the two sides, when they walk out of mediation, they have settled their differences. They may not get everything they want, but they get what they need to move forward. And they obviously recognize the value of mediation because of this 80% success rate, versus you go to court, maybe it works out well for you, maybe it doesn't. No matter what, you're going to pay for the experience, literally. So That's how mediation works in business. It is a way to utilize a third party to negotiate a resolution that is not all you, it's not all them, but it's what both sides need to move forward. That's the essence of mediation in business. We've talked a little bit about the costs and the benefits of mediation, but let me try to put a little finer point on that. I did some research in preparation for this presentation, and I want to share some of these figures with you that you might find a bit startling. These statistics aren't current, up to date, but they're pretty recent. And by that I mean 2018, 2019. In 2018, on a national scale in this country, $245 billion was spent in litigation costs for businesses and individuals, which, if you do the math, is about 1.3% of our gross national product. 1.3%. Now you might say, well, okay, 1.3%, that doesn't sound like much. Well, for comparison purposes, our defense budget is 3% of GNP. So we are spending about half of what we spend on national defense, which we all know is a lot, on litigation costs. That's on a national basis. Let's talk about Florida. We could talk about California or New York, and you would be astounded at what litigation costs in those two states are. Being in the South, things aren't quite as expensive, but they're getting that way. In Florida currently, I would dare say that I don't care how small your problem is, how small your business is, you can't hire an attorney probably for less than a retainer of at least $2,500 to $5,000 at a minimum. I don't care what your problem is. Hourly rates in Florida, you would be hard pressed to find a lawyer who would take your case and charge you less than $200 an hour. The average hourly rate in Florida is probably closer to $300 to $400 an hour, and in South Florida, it is well in excess of $500 an hour. The lawyer's tools in Florida, depositions, which are the sworn statements of witnesses. Depositions average about $1,000 per deposition. And these are the hammer and nails for lawyers. You can't take on a case without conducting at least a handful of depositions to find out what these witnesses know, what they're going to say, and more importantly, to keep them from saying something else in court to get their words in stone. That's the primary function of a deposition. Experts in Florida, like elsewhere in the country, it's not unusual for experts to charge between $500 and $1,000 per day for their testimony, whether it's a deposition testimony or in trial. Medical experts are you would be shocked to hear what it costs for medical experts. Not unusual for it to be $10,000 a day. Trials, general rule of thumb is trials will run you probably between $5,000 and $10,000 per day for a trial. And in Florida right now, I touched on this a little earlier, but in Florida right now, it takes about 1.5 to 2 years to get a case set for trial. Again, we're doing better than California. California, it's more like 5 years to get a case for trial. Florida, we're heading in that direction, but we're not there yet. So you can certainly see why litigation is not very efficient, not very cost efficient, or time efficient from the standpoint of being a good tool for business to use to resolve disputes. Mediation, on the other hand, a mediation will cost each side, and because the mediator is neutral, the mediator is paid either by the hour or by the mediation. When I do mediations for insurance companies, they pay me by the hour, as does the other side, half of the fee. When I do mediations for businesses, such as your business, it is a flat fee. It is a flat $500 per side for the mediation. So, and that's for a half-day mediation. So basically, to compare mediation to litigation is really no comparison at all. $500 for a half day per side versus probably minimum $5,000 to $10,000 in litigation costs, with really a better chance of resolution, 80% versus I don't know what the trial percentages would be in terms of winning versus losing. I suspect it's probably about 50% cases that go to trial result in plaintiff's verdicts, 50% result in defense verdicts. More importantly, in mediation, unlike in either arbitration or litigation, once you've submitted yourself to an arbitrator or to a judge or a jury, they are making the decision that you will live with. What we touched on at the very beginning in terms of describing mediation and describing its advantages, it's a self-determinative process, meaning that the participants are deciding whether or not they are going to resolve their dispute and on what terms. They're not having someone dictate to them the result. So it is self-determinative. Now, that doesn't mean that it's a guarantee that it's going to resolve, but what it does guarantee is that you will decide, and your counterpart, with the help of the mediator, you will decide whether or not you're going to resolve your case or whether or not you can't resolve it. The divide is the gulf between the two of you is simply too great and can't be bridged. And that does happen, but it only happens about 20% of the time. The other 80% of the time, this happens. And both sides recognize that it's in their best interest to resolve the claim, even if it means having to give some things up, but getting something in return and making it enforceable, so that unlike sometimes promises that are made in business and that are broken, this is an enforceable agreement, enforceable in court as an agreement with an 80% success rate. So you can kind of see that, and the picture there of the dominoes. The other thing that mediation does is it stops both sides on the track that they're going down and resolves it, as opposed to the dominoes continuing to fall, the costs continuing to escalate, the time continuing to go forward with no resolution in sight, and the parties getting farther away because now they have more invested in it. They've got more time invested in it. They've got more attorney's fees and costs invested in it. They're almost like, I can't go back now because look what I've already spent. And so the case continues to barrel down the track of litigation, and ultimately a jury will either agree with you or disagree with you, and you'll live with the result. Mediation is designed to put a stop to that so that your time and your money can be better spent focusing on business and less on this dispute that you're having. So the last one that I'd like to share with you is this one, which I think kind of, they say a picture is worth 1,000 words, and I think this picture probably says better than I have been able to say in the last 20 minutes or so, the differences rather stark differences between litigation and mediation. And so I think that picture kind of says it all. I'm kind of reaching the end of my talk. I was prepared to talk about just a tiny little example. I mean, you might be saying, well, gee, well, okay, I kind of understand it, but how would it work? How would it work? Nuts and bolts. How does it work? Let's say we have an imaginary company. Let's say I've got a company and I make these really neat binders for individuals, for businesses, and I've got a contract. I've got an order for $30,000 worth of these binders with someone across town or someone across the bay, and I manufacture them, I make them up, I deliver them, and the purchaser says, well, these are useless to me. These are useless to me because you've misspelled our company name. So I'm not paying for them. Now, there is a way, let's say there is a way that you can modify them to make them usable. It's not as good as it was, but it's certainly usable. And so you try to explain this to the other side, and the other side is saying, nope, we didn't get what we asked for, what we contracted for, and so we're not paying you at all. Now here you are in a dispute. And by the way, they're keeping all those binders. They haven't shipped them back to you. They're keeping them, but they're not paying for them. Now, what are your options there? Try to work it out with them. But you're not able to work it out with them. Now your options are getting more limited. You're out the time, you're out the material, everything that it cost you to make them. You haven't gotten anything back. So what do? You hire a lawyer. The lawyer says, sure, you may have some problems with the case, but I can represent you. I think that we can probably win this case. I'm going to need a $2,500 retainer that I will bill against at $250 an hour for costs and for my fees. It's probably going to take us, a year and a half to get to trial. It's probably going to run you anywhere from $5,000 to $10,000 to get the case ready for trial, and then it's probably a 2-day trial, and that's going to cost you probably another $5,000. But if you win, some of those costs we'll be able to recover if we're the prevailing party, because in Florida, the prevailing party is entitled to recover their costs, not their fees, unless you have a contract that provides for that, but your costs. Of course, if you don't win, you get the privilege of paying the other side's costs, since they're the prevailing party. And so that's what he proposes to you. And so your choices are, you haven't been able to work things out with the other side. So your choices are either hire the lawyer, go through the process. Hopefully it works out for you. It's going to be painful and it's going to be expensive, but hopefully it'll work out for you in the end. Or suggest to your counterpart that each of you submit to a pre-suit mediation that will be presided over by a neutral mediator. And each side, you can hire a lawyer if you want to, but it's not necessary. I do mediations all the time where the principals are not represented by counsel, and they know how to talk. They know how to make their points, and with some asking of questions, so that I can find out a little bit more about what happened, about the issues in the case. I can speak intelligently with the other side when you're not in the room, and we can meet together. As I said, before we did this by Zoom, we would meet downtown in my offices, which has a large conference room and about 4 smaller conference rooms, so that once we're together, and all I require 2 things. I require that each side listen and not interrupt when the other side is making their presentation about why they think they're right, and be respectful. You'll get your turn. And then I require that of the other side, so that once each side gets to kind of make their presentation, then we split up into separate conference rooms. One side goes into one side goes into the other, and I go back and forth, and I meet with both sides, and I ask questions. and I will sometimes play a devil's advocate role. Well, what about this? I heard what you said, but I also heard what they said. What about this? And the idea is to get people thinking not so much about that they're 100% right on every point, but to be able to concede that maybe the reason why there is a dispute is that there is some merit to both sides. Now, what do you need? What do you need? Don't tell me what you want. I already heard that. Tell me what you need. And then by taking those things to the other side and doing the exact same thing, we get people to move off of their original positions to a position of conciliation. I tell people that at the end, if we've done this right, both sides are probably, what I would say is, they are palatably unhappy. Palatably unhappy, meaning they didn't get everything they wanted, but they got what they needed to move on. They got what they needed. They've got an enforceable document that is enforceable in court. It only costs them 3 hours of time and $500, and they've got a deal. Now, why couldn't they do that themselves? What I can tell you from having done mediations for a fairly long period of time, been a mediator since 2003, is that there is something about the dynamic process about individuals getting together, but with a neutral party who is kind of a referee, but a neutral party that has the ability to see both sides without making a decision, but at least being a sounding board, being a devil's advocate. It works. Like I said, the statistics don't lie. It works about 80% of the time. So this is a nuts and bolts, garden variety mediation for business, which I hope kind of paints a little bit better picture from a procedural standpoint, how mediation works and what happens during a mediation. As I said at the very beginning, it is a voluntary process. No one can make you do anything. The mediator certainly can't make you do anything. It is confidential, meaning that nothing that's said can ever find its way into a courtroom. You can never, if the case ultimately went to a trial, you would never hear either side be able to say, well, in mediation, you agreed, you admitted X, X, Y, and Z. Absolutely verboten, because it's designed that both sides can be candid to be able to say, okay, I will agree with you on this if you'll agree with me on that. If you can't agree, no one gets hit over the head with it. So this is how mediation works. I think that pretty much covers the waterfront in the things that I wanted to talk about today. Be happy to answer any questions that anyone might have. As I said, we live in a Zoom world now, so until further notice, I've had 2 last week, and I've got more this week. We do mediations by Zoom, and since everyone here knows, at least has a fairly good concept of what Zoom is, we virtually put the two parties, we meet together like we are right now, talking to each other, and then I put the parties in separate breakout rooms, just like a virtual conference room, and then we do the exact same thing. I meet with both sides, I ask questions, I ask them, okay, what about this? Okay, what offer would you like to make? What's your response to that offer? And the various techniques that mediators use to get parties to compromise, to resolve their differences, resolve their disputes, to get to that document, that enforceable document that says this dispute has now been resolved and both sides will live by that resolution and a court can enforce it. So thanks for listening. If there's any questions, be happy to try to answer them. Yes, ma'am. Is it Debbie?
Thanks for speaking today. It was very enlightening. I have 2 quick questions. The first one is, if I have a vendor, how long, using your example about you did the books for somebody, how long can they come back after somebody? Let's say, I mean, is there a time frame? Is there a something involved? Like, can somebody come after you 7 years later and say, you never paid me for XYZ? And my second question is, sometimes there's a contract saying if it goes to dispute, it has to happen in the county where it occurred. Does that go out the window with Zoom?
Those are great questions. The first one is a legal question. It's a fairly easy question to answer. In Florida, the statute of limitations for contracts is, if it's a written contract, it's 5 years. If it's a verbal contract, and lots of, I'm always amazed by what people think that a contract has to be in writing. There are really only about 3 contracts out of all the millions and zillions of contracts that people can get into. There's only 3 types that must be in writing. One of them is to convey real estate or any interest in real estate. I think the other one has to do with probate, and the third one escapes me. But the vast majority of contracts can be verbal. Verbal contracts, you have 4 years to bring a lawsuit, or it will be thrown out because it's outside the statute of limitations. Now, people say, well, 4 years from when? 4 years from when, or 5 years from when? And what courts say is, it talks about when does the cause of action accrue, meaning when could you bring a case? When is the earliest you could bring a case? So for breach of contract claims, like you've described, someone sells something and the other side doesn't pay for it. Okay. The soonest when that cause of action accrues is, when was the money due and wasn't paid? That's when it accrues. So it would have been 4 years in the case of an oral or verbal agreement, or 5 years in the case of a written contract. 5 years from when the cause of action accrues, which, if you're talking about the person who didn't pay, it's when they didn't pay. Let's say your contract says, well, you're going to pay me on the 1st of January. 1st of January comes and goes, and you haven't received payment. You could run down to court on January 2nd, file a lawsuit, because your cause of action is now accrued. So it'd be 5 years from that date. So that hopefully answers the first question. As far as contracts that have what's called a venue selection clause, venue means where can the case be brought? Typically, in Florida, if there is no contract provision that says where the lawsuit must be brought, where venue must take place, there are several different choices that litigants can choose, and the plaintiff gets to choose since they're the one bringing the case. The first one is, where did the cause of action accrue? Again, in a contract case, if you're the seller and the buyer didn't pay you, the cause of action accrues when they didn't pay you. And by paying you, they have to pay you where your office is. They got to send, back in the old days, it would be, you'd send a check in the mail. Now we do Venmo, and we wire, we do all kinds of ways of paying, but the result is still the same. They were to pay you where you are. So the cause of action accrues where you are, where your company is. If it's Hillsborough County, it's Hillsborough County. Second one is, you can choose to litigate in the county where the defendant resides, which, if the defendant is a company and their main office is in Tampa, Hillsborough County. If it's in Pinellas, it would be Pinellas County. But you may prefer, since you're in Hillsborough County, why would you want to litigate in Pinellas? Or even worse, what if it was Dade? You have to go down there. It's going to be more expensive for you. You'd rather litigate in Hillsborough County. Okay, so that's how venue works. In terms of mediation, here's another beautiful thing about mediation. In mediation, you're not beholden to those venue provisions, because the venue only describes where the lawsuit has to take place. It has nothing to do with where the mediation can take place. So it doesn't matter about whether it's Zoom or in person. That venue clause in the contract is not going to prevent you from mediating a case in Tampa, even if it says any lawsuits that result from this, the venue has to be laid in Dade County. So what? We're not litigating. We're mediating. So you wouldn't be bound at all.
Thank you.
Any more questions for Matt?
Well, I'd like to make a comment, real quickly. If I listened to every word you said, You know, first of all, you said that nobody lives in a perfect world. I'm looking through the people in this room. I think Sharon lives in a perfect world, and same Diane Stoddard and Debbie Ryan. I think, you know, they live in a perfect world. They never have anything they go is wrong. But in a mediation, it's probably both sides. One side thinks they pay too much, and the other side doesn't think they got enough. I mean,
Of course.
isn't that in the nutshell?
Of course.
You know, of what you're doing, and it really makes sense, because what happens the other way, the only one that really makes out are the attorneys and the court.
Well, and I'm not, yeah, I think you make an excellent point, Jeff, and I certainly am not knocking attorneys. I want to be very clear about that. I am an attorney. I have practiced law for almost 40 years. I like to think that in each and every case, I provided a valuable service to my client, but that's because my client chose that path, you know, for whatever reason. Before there was a thing called mediation, they didn't really have much choice, because if one side says, hey, I'm not paying you, or one side says, you know, I didn't do anything wrong, so sue me. That's all you had available to you, really. Mediation is a way of kind of getting in the fast lane, if you want to be honest about it. It puts you in the fast lane, as opposed to the slower lane. But that's not a knock on lawyers. I want to be real clear about that.
You know, it's not a knock on lawyers, but sometimes you need an attorney to protect you from your own attorney, you know, because at the end of the day, they don't want to solve your problem, because if they solve their problem, there goes their billable hours. I mean, you've hit the nail on the head. Lawyers, like other professions, they you know, their stock in trade is time. And so the faster something gets resolved, the less time, and that's all they've got to sell is time. So yeah. My goal is to try to get people to, again, I use the term self-determination, get people to say, okay, you know, I tried to resolve it, but you know, we're, you know, he's not listening to me. He's not listening to me, or maybe there's a personality conflict there or whatever. So you really need this third party, this Switzerland. Or, you know, I mean, again, I don't mean this pejoratively, but, you know, you got brother and sister that can't get along, and sometimes mom becomes mediator. She doesn't love brother more than she loves sister, or vice versa. She knows that each have their point of view, and somehow mom, by listening to both sides and by asking brother or sister, well, now wait a minute, I hear what you're saying, but you know, your sister's making a good point too. You know, she's not being mean about this. She just has a point of view that's different than yours. And I'm not saying it's as simple as that. It's not. But over a period of time, and with the experience and the education of knowing where the bodies are buried, where the stress points are in the case, and understanding by meeting with each side individually and getting from them confidentially, what is it you really need? What are you really after? I know what you want, but what are you really after? I won't say it's magic, because it's not. What it is it's human dynamics. It's human dynamics is what it is. Well, I think
I'll give you a short little analogy, which actually I've used over and over and over again. Settling a case in mediation is a lot like going to the car dealership. You're going there saying, I want to pay as little as I can for this car. The car dealer wants to make you pay as much or as close to retail as they can. Do cars get sold? Absolutely, they get sold. Where do they get sold? They get sold in that showroom when that salesman is bouncing back and forth with the owner. Now, maybe you'd say, well, the owner gets the better. You know, he's getting the better of the car buyer. And I'd say, no, because car buyers, at the end of the day, the car buyer is getting what the car buyer needs, getting the car. He didn't get it for free. He didn't get it for 50,000 off of sticker, if we're talking about a, you know, Tesla or a Mercedes or whatever. But at the end of the day, he's the one that decided, okay, I'll pay X to get what I need, which is this car. I'll pay it. And if not, what does he do? What does she do? She walks. And she's invested a couple of hours at the dealership. Either she got the car or she didn't. Mediation works remarkably similar to that.